మీరు వింటున్నారు తెలుగు NRI రేడియో. ఇది ప్రవాసాంధ్రుల గుండె చప్పుడు.
Hey, what's up? Hi, my crazy listeners and my crazy callers. Welcome you all to the most beautiful and the most entertaining and the world's most craziest, in fact, the costliest one and only show, Express Raja, oka manchi cocktail show. And nen mi RJ Shashank. Welcome you all to the marvelous Monday. Manchiga మా దగ్గర అయితే లోకల్ టైం వచ్చేసి 7:01 AM అండ్ ఇండియాలో లోకల్ టైం వచ్చేసి 8:30 PM అండ్ ఫుల్ రెయిన్, 2 days ఆఫ్ రెయిన్. ఆల్ మ్యాచెస్ వర్ క్యాన్సిల్డ్ అండ్ కంప్లీట్గా హౌస్ అరెస్ట్ అయిపోయినాం అనమాట మేము ఇంట్లో. బట్ హియర్ ఇట్ గోస్ విత్ అ స్పెషల్ ఎపిసోడ్ విత్ అ స్పెషల్ టార్నీ హూస్ ఫ్రమ్ డాలస్ and his name is Lucas. And we have him as a special guest to discuss on all the immigration-related queries, questions, and the current immigration system, or current immigration processes, current immigration challenges. At the same time, we have this hot topic called Farmington University issue. I'm sure we are going to discuss with Mr. Lucas on this in a very detailed way. So, welcome you. I grandly welcome you to Telugu NRI Radio, Mr. Lucas. Good morning. How are you doing?
Good morning. Namaste. Thank you for having me.
Thank you, and namaste to you too. And we have calls as soon as we started. So let's discuss this. I'm sure there is a hot topic that's going on right now. This Farmington University students issue. So, what do you think exactly happened? And I'm sure pretty much every listener who's listening and then everybody knows this, but still, I'd like to know from attorney's point of view, what exactly do you think happened?
Well, the Farmington case is actually a case similar to what happened a couple of years ago in New Jersey, where Department of Homeland Security created a fake university in the attempt to, find people who help do recruiting for profit, which I think this time there was a number of people arrested and charged with federal immigration crime. The unfortunate part of this is most of the students are unknowingly participating in this event, and about 600 students, from what I understand, have been arrested by ICE and issued notices to appear for immigration court, which begins the removal or deportation process, but we call removal proceedings.
All right, and why? Here comes a question, Lucas. Why do USCIS, or why does this DHS or USCIS or this group has to create a fake university? Like, why do you think it is?
Well, I mean, I think our current president and this administration is really focused on any way possible to limit the number of non-immigrants, such as students, or immigrants, the people who want to come here with GC. We've heard a lot of discussions about a wall. We've heard a lot of discussions about other programs that have been implemented, which most immigration attorneys believe has been implemented illegally because they haven't followed the administrative law rulemaking process. And it's just a reflection of, I think, of this administration where, the president actually says he wants to make America great again, or put America first, hire American, buy American, hire American, So I think you could just read between the lines of the focus is to limit people who want to come here legally and invest, in education, invest in our economy, pay taxes, So it's a broad spectrum that's been affected by a lot of the policies that have been implemented.
All right. So a slightly complete different point that I'm going to question that I'm going to ask you apart from this immigration. Have you tried this modeling or acting career, Lucas? You look great in the picture, honestly.
No. What have I? one of my clients is a movie producer, so I tease him, about he's currently making a movie in Telangana, and I tease him about maybe making a cameo appearance in his movie.
Of course, you look great. So
Oh, thank you.
deserve that. and charge him $1 million, definitely.
Sure.
He's gonna pay you. So going back to the subject, so what is their situation right now? Like, what do you think is this USCS going to do with the students, or what's the status of the students?
I have a couple of clients who are affected by this,
Okay.
and depending on where, this was a broad swath across the United States, so there were students literally every state affected. The day before all this happened, I think it was last Tuesday. The CVIS was canceled for all the students. And then Wednesday, most students woke up to ICE or Homeland Security investigations or someone coming to their door and detaining them. There's different policies for different locations. A few of my clients were not issued bond.
Lucas,
So
I'm sorry to interrupt. We have a caller who wants to talk to you. So let's take a call really. Express Raja Show ki swagatam. Hello. Hello.
Hello.
Can you hear us? Hello. Yeah. May I know who's this on the line?
Hello.
Hello. Hi. Can you hear us? Who's this on the call?
Sir, నేను మంజునాథ్ రెడ్డి బెంగళూరు నుండి.
All right. మంజునాథ్ నమస్కారం అండి.
నమస్తే, నేను మంజునాథ్ రెడ్డి బెంగళూరు. ఇది వాట్సాప్ గ్రూప్ లో వచ్చిండే తెలుగు ఛానల్లో సార్. ఇది తెలుగు జనితా రెడ్డి అంటే ఎవరు సార్? వాళ్ళు
జనితా రెడ్డి అనేవాళ్ళు ఇమిగ్రేషన్ అటార్నీ సార్. మనకి యుఎస్ లో అమెరికాలో ఇమిగ్రేషన్ ఛాలెంజెస్ ఉన్న వాటి మీద క్వశ్చన్స్ స్పెషల్ షో చేయబోతున్నాం. అర్థం కాలేదండి.
ఇప్పుడు మాట్లాడతారు, సౌండ్ కమ్మి వస్తా ఉండే. చెప్పండి సార్.
ఇది ఇప్పుడు ఇమిగ్రేషన్ అటార్నీతో ఒక కాల్ అవుతుంది అనమాట ప్రస్తుతము. సో అది స్పెషల్ షో అనమాట, గెస్ట్ ఇంటర్వ్యూ నడుస్తుంది అనమాట. సారీ, కాల్ కట్ అయింది. సారీ Lucas, you were saying something actually. Let's proceed with what we are saying.
So basically, ICE DHS, I believe we were talking about custody. Not just for everyone's knowledge, in America, we have certain core rights. We have our Bill of Rights, which in part give us the right of freedom of speech, the right to an attorney if we need one, if we can't afford one, the right to bond, many other rights as far as fair trial, speedy trial, things like this. That's in a context if you're proceeding through a criminal case. If you are affected by an immigration matter, it is a civil case. So a lot of the protections we have aren't readily available because because most of all the students are being held with civil detention. So if you're being held in civil detention, the ICE or whomever can deny bond, and you can be held until you can request an immigration judge to have a bond redetermination to see if you can not be a risk to the community or flight risk or other things. But there's no right to a bond. Just like if you were charged with murder or something, there's you'll hear sometimes people will have a bond of $3 million. It doesn't mean they can make the bond, but at least a bond is set. Some of these students, a few of which I represent, there's no bond set, and they have to wait 2.5 weeks to have their hearing before a judge.
Makes sense. All right, we have a caller on the line. Let's take his call. Express Raja Show ki swagatam. Hello. Hello. May I know who's on the call? Hello. Hello, can you hear us? May I know who's on the call, please? There is a disturbance actually. Call left. I'm so sorry.
That's fine.
So if you have any immigration-related questions or challenges or any queries related to immigration, especially on your current statuses or your friend status, or you want to ask on behalf of your friends and stuff, please feel free to give us a call on 970-522-0005 from India, and US నుంచి అయితే 919-701-2005 కి, and UK నుంచి అయితే 115-888-2005 కి. Skype నుంచి Telugu NRI Radio అని యూజర్ అని యాడ్ చేసుకొని you can give us a call, and you can feel free to ask Lucas any immigration related questions, and also you can email us your questions on Telugu NRI Radio @gmail.com ki, and feel free to give us a call. Sorry, Lucas, we were getting interrupted. So just go ahead with what you were saying actually. So the civil case and the status.
Right. So if you're put in removal proceedings, just for everyone's information, so this past Wednesday, for example, if ICE came and arrested a student who attended Farmington, their CVIS expired, they're now out of status. When that process begins, USCI, their ICE will issue a notice to appear, which starts the removal proceedings, and they'll also keep the passport. So even if you do have bond, you're not free to travel or leave until you conclude your court hearing.
All right, makes sense. Before we proceed on this, we have a caller added. Express Raja Show ki swagatam. Hello, can you hear us?
Hi.
Hi.
Yeah, I can hear you.
All right. Can you brief your question to Mr. Lucas, please?
Okay, I don't know if this topic has already been covered, but I just called to see if I can have some information regarding this. Okay,
Sure.
so I'm in a situation where I got my initial OPT in 2015 and used like 3 years of my OPT. I mean, OPT and STEM extension. And then now I shifted to CPT and on my 3rd semester right now, which is what I'm doing. So what is my situation? Like, am I on the safer side, or should I be worried about what status I'm in right now?
Well, that's a good question, and we've seen an increase of this this year as far as H-1B RFEs, focusing on the OPT, CPT maintenance of status. So the main requirement is at all times you're supposed to maintain your non-immigrant status, and that's reviewed when you apply to change status. In this example, F1 to H-1B. What you would want to do is make sure you have a detailed record of what you've how you've maintained your status over the past 3 or 4 years, right? So you have to work at least 20 hours per week related to your major or study for your OPT and for your STEM extension, right? When you did your I-983, you're supposed to have a training plan. You're supposed to have it, something that corresponds with what your degree is and how you're getting a real world experience, right? And if you go then and extend your stay with CPT, so you're going to go for second masters, okay? Typically, and this is kind of a gray area, typically you're supposed to always advance a degree. So if you come here and to the United States, you get a bachelor's, you use your OPT or CPT, whichever one you use. Whenever you go again for the next degree, you're supposed to then go for master's. So, it's not necessarily good to do second master's. However, if there's nothing illegal about this, as long as you have documentation about the other CPT program, and what is required for the training or for the lessons, how does it link? How is it an essential or integral part of your degree program at your new university? Does that make sense?
Yeah, definitely. That makes sense to me. So it doesn't matter if it's a day 1 CPT or the CPT extended, right? Because I don't know how far this is true, but Yeah, I've been hearing a lot about day one CPT, and they say you're not supposed to be doing a CPT from day one, but
it's there's not anything set in stone like that says that it is illegal or not. I would recommend to not, it kind of circumvents what the meaning of the program is. I would not, unless there's just dire circumstances, I would never recommend someone do day one CPT, right? Because the CPT, you need to show that you're going to school for 1 year, right? And the day one CPT says, well, you already have experience from the previous degree, so you're going to get kind of an internship and then go to school. So what happens if next March you get picked in the lottery, okay, and you never attend the rest of your coursework, right?
Right.
So there was a memo issued last summer, that says any person found to be without lawful status after August 9th, they can go back in time to determine when that person's lawful status began. You see? So that's a similar trick or something that they're trying to implement, similar to right now for the H-1Bs. If you've heard about the extensions where, now they can go back and adjudicate whether or not the original H-1B should have been approved or not. Okay. There is a lawsuit from IT-Serve that's challenging that because they didn't follow the administrative rules process where, the government says, I'm going to change something. They have to post the proposed rule. They have to receive comments from that and then, make the changes accordingly. You can't just change a rule from day to day. Now, that doesn't mean it won't affect you, but, that's something that's been challenged right now. And I hope that helps answer your question.
Yeah. Also, a quick question, if I could ask you something related to the second master, since you mentioned that. Okay, my field of study during my first master's program was electrical, but then I've shifted back to computers. Shifted to computers for my work, which is IT. And now I'm doing a degree in the IT itself because I didn't have any prior master's degree in the field of computers. So does that come under the same degree level or?
It's the same degree level because we're looking at a progressive trend as far as obtaining the next level of education, which would be bachelor, associates, bachelor's, master's, doctorate, right? So just because you're changing your major or pursuing a different degree that's still master's, it still falls under umbrella of a master's degree.
Okay, so at this point, do you suggest changing to PhD? Because I spoke to the university and they were like, well, apply for a PhD if you really want to do a PhD. And
what school are you attending?
At the University of the Cumberlands.
Okay, Cumberland. That's another day one CPT school. I've seen a lot of that. You just, you want to make sure that, again, that your documentation is correct. So if you do want to pursue PhD, you still need to show why the coursework is required for you to have this CPT internship, so to speak, right? What's directly related? So you're working as a .NET or Java developer or something like this. What is the integral part of that from your coursework that corresponds to this? You see, and your DSO or the university itself should be able to provide all that information to you. And it's important that you get that information before any issue of RFE or, any other issue might arise. So you have all your evidence with you. Okay.
Makes sense. Yeah.
Thank you so much for your call.
Thank you so much.
Yeah. Good luck to you.
All right, because it was a very detailed explanation, and thank you so much. I appreciate it. And so we were actually going ahead with this current status or current situation. So what next? What's next for them?
For the students who are detained?
Students of Farmington, yes.
Well, each student will go through the removal process, and in some circumstances, the officer might allow the student to sign voluntarily an order of removal, which would allow them to return home, but they would have the 10-year bar to re-enter. Then it's a popular subject with some of my clients. They're interested in a request for voluntary departure. Okay. So a voluntary departure, and if they're detained, would be under safeguards where the immigration judge would allow them to voluntarily leave the U.S. and it would not affect their future immigration status as far as unlawful presence or anything like this. But the caveat to that is if you're detained, it could be a couple of weeks before you have your initial hearing, and it's discretionary from the judge himself. So the judge might just deny and want to proceed with the removal proceedings. And at that point, I knew a couple of gentlemen from the New Jersey case. They were out on bond, and it took them about a year and a half to conclude their case so they could go back home. But during that time, they're not permitted to work. You see?
Okay. Yes, makes sense.
So it's very tough, especially if there's family here or separated back home. So.
Yeah, I mean, there is a lot of mental trauma for sure, right?
Correct.
Again, going back to the question, what's the fundamental reason for this creation of fake university, and they are offering CPT, day one CPT? I understand they want to clean up some junk or make in America or great America and stuff, but why? Why do they need to make puppets out of this whole scenario?
Well, unfortunately, that's been the common trend, not just with the students, but with H-1B visa holders, L-1 visa holders, people going for GCs. Employment-based visas now require an interview. So there's a lot of changes where they're trying to make it more difficult. But in this case, the belief is, which I don't agree with, but they believe that students coming here on CPT or OPT are taking away jobs from Americans who could do the same type of work. Anyone who's familiar with the process or the industry knows that it's not so easy for CPT or OPTs to get a position just because they're new, they're fresh, they're freshers.
That makes sense.
H-1Bs, as everyone knows, is highly regulated. We have to file amendments every time you change a workplace location in a different area. You have to pay the minimum of a prevailing wage. Okay, so there's a lot of protections that are already in place to protect the American worker.
For sure.
Yeah.
All right. So going back to the question, I have this question actually. There are cases where we see, irrespective of transfers or irrespective of amendments, H-1B amendments, or irrespective of new filings on H-1s, I see these specialty occupation cases a lot. Like, how do we deal with this? And I'm sure there is I've had this situation where I got specialty occupation where I'm into a computer science background itself, but I cleared. That's a different story. But how do we deal with this specialty occupation issue? Like, especially students from the current working industry is completely different from what they have done in the past, meaning in terms of education background and stuff. So how do they deal with it? How strong they can make their cases? Like, what's your suggestion on this?
Well, that's a very good question. So as with everything, there's a caveat to this. Also, this past year, there was not just a standard specialty occupation RFEs, but they've introduced availability of specialty occupation work at a third-party location type of RFE. Okay, these are saying from this Hire American, Buy American policy the president signed that USCIS wants to validate all the layers or vendors between the end client and the petitioner, which would be the employer of the H-1B beneficiary.
Okay.
in the past, we would, send a client letter or maybe SOW, PO from the vendor, and that would help establish the right to control, the specialty occupation, things like this.
Okay.
Now, they say that that's not valid, not enough evidence. You need to show the contract between all layers. So some layers, you might have 3 layers, or with the implementation vendor or something like this. So TCS might not be interested in sharing a contract with their client, even though the client gives an in-client letter. We are starting to see an issue with that.
Yes.
Does that make sense?
Makes sense, absolutely.
And as far as specialty occupation goes, when you have a H-1B visa, you have to have a visa in specialty occupation. So even if you're LCA, you file the SOC code that is established by the Bureau of Labor Statistics to require a bachelor's degree in computer science or something similar. The USCIS will also focus on, do you have a degree in a specific specialty? So electrical and electronics engineering obviously has something to do with computer programming, but they'll challenge that. And when I say they, the service will challenge that. And it's just a challenge on everything right now. And it's very unfortunate because there's a lot of people who have families, who buy houses, who have cars, who have invested time to be here in America and want to be here.
And shattered overnight.
Yes. And it's unfortunate. I've spoken to many people who have had to just pick up and go the next day. And sometimes we're able to help, because large companies like Cognizant, if your case is denied or something happens, they basically say, here's your plane ticket. You have until this day to leave. Sometimes we're able to help someone, find new employment, But.
For sure. I have a few more extension questions related to this. I mean, to what we just spoke. But we have a caller. We can take a call really quick. Express Raja Show ki swagatam. Hello.
Hey, hi.
Who's on the call?
Can you hear me?
Yes.
This is Vinay Kumar.
Hey, Vinay. You can ask a question to Ms. Lucas.
Yeah, hi, Lucas. I have a question on my H-1B. So in the year 2017, my H-1B was approved with employer A, and it got revoked in the month of September 2018. But before it got revoked by USCIS, I have already initiated a H-1B transfer to employer B. So, how long can I stay legally on my H-1B transfer receipt?
Well, for company A, why was your H-1B petition revoked?
So I'm not sure about the reason. The USCIS has came back and was saying your in-house project has been plagiarized. So that's the reason they have revoked it. But however, before it got revoked, I already initiated my H-1B transfer to employer B. So
very good question. So
Lucas, I have a question. I still have a question to his what Vinay asked actually, and it's a question to Vinay for sure. And I'm sure you're open to answer this too. Why did you have to initiate H-1B transfer to an employer B before it was revoked? Did you have any clue?
So before it got revoked, we got an intent to revoke notice. So which we have 1 month of time to respond to that. So we thought to be on the safer side, I thought of initiating the H-1B transfer.
Makes sense. All right.
Yeah.
Okay, it's a good question. Good follow up. The issue on your case right now is going to be you're going to probably get an RFE on your case that says that you're no longer a CAP exempt employee. So when you file the transfer, you base the transfer that you're CAP exempt because you have a previously approved H-1B petition from the fiscal year 2017. Now, when that petition's withdrawn or denied or revoked due to fraud or plagiarism, whatever it was, you also lose your ability to be CAP exempt. So you're gonna, if your company has not received a new RFE or intent to revoke or deny, then it should be coming pretty soon. Now, you want to be careful about this because you don't want to accrue unlawful presence. Go ahead.
Yeah. So how long can I stay like on a H-1B transfer receipt, like legally? Like my employer was saying, I can stay legally for 180 days from the day the revocation has happened.
No, I mean, if you stay, that's still overstaying. You have 20 days or so to depart. The 180 days is if you're less than that, okay, then once you get to 180 days, you have a 3-year bar. If you stay longer than that, you could get to 10-year.
Okay.
That your employer, and this is why you have to be careful. So your employer might want to say, I want you to stay working here, because all you have to show them to legally work here for your I-9 is you have to show them and approve, your I-94 giving you the status and your passport, right?
Yeah.
So they file the change of employer, case, even if they know that you're having these circumstances, you can still legally, technically be employed until they have noticed that your other case was revoked, and then, they're not going to approve the transfer. So they might want to keep you here as long as possible to keep the billing rate going, right?
Yeah.
And my advice would,
Okay.
Yeah.
Go ahead.
So
please.
What's your advice on my status? Like, you want me to go back and get onto F1 stamping again, or?
Well, I would recommend you depart the country as soon as you can, and your H1 case can still be adjudicated if you go back home. All you would be required to do is get stamped if your case is approved. If, let's say, we don't know all the circumstances. What if your case is approved? Everything turns out fine. You can come back on H1.
Okay.
That's just to protect yourself. As far as going and getting re-stamped on F1, you might have issues with that. What status did you enter on F1?
Yeah, I entered on F1 status in the year 2014.
So if you go get re-stamped, you're gonna have an issue to show you're progressing in the degree itself. So if you go, I don't know which consulate you go to, but if you go to Hyderabad or Chennai or whichever one, the officers are going to focus on your intentions of being a student itself, and and so now we come back to the question of the OPT, CPT, and progressive degrees, right?
Yeah. So I have applied for the PhD program from the same university where I did my master's. So I want to get F1 stamped. So do I necessarily need to go to my home country, or can I go to Canada or some Mexico for stamping?
It's possible to do that. It's always best practice to go back to your home country, just because it's a non-immigrant visa. You also, most people don't realize this, H-1B is a non-immigrant visa, but it has a dual intent. So it's to say, I want to stay here. I don't want to go back home. I want to stay here. So if you already changed to that, there might be some doubt whether or not you're promised to return home when your F1 visa expires, right?
Yes.
The best course of action would be returning home to have that type of stamp done. You can also change your status, but I guess the question would become if your I-94 is valid still or not. And if your original petition was revoked, I would strongly suggest it's probably not valid anymore.
Yeah, it is not valid anymore.
Yeah.
All right. Thank you so much. Hope that answers your questions, Vinay.
Yeah, good luck to you.
Yeah, thank you.
Bye-bye.
Thank you, Vika.
All right. So going back to the question slightly, an extension question of what we were discussing on this employer-vendor-client relationship and the documentation and the specialty occupation. So current situation, how risky or how, what's the situation on, I'm sure if there is a employer, vendor and client, I'm sure this is that's not going to be an issue when we go for stamping. But how about the first-time H1 stamping going candidates has more than one layer, meaning vendor, and he has a preferred vendor and then employer, and then client is already there. So what do you suggest to them?
It's a very good question. What I've seen over the past year.
And sorry, Lucas, sorry to interrupt. We have 2 more calls
sure.
before we take this question. Express Raja Show ki swagatam. May I know who's on the call, please? Hello?
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 Yeah, who's on the call, please?
Hi, can you hear me?
Yes. Who's this?
Hi, this is Murli.
Hi, Murli. There is one more caller. Who's on the call, please? Can you hear us? All right. I think one more call left. So, hey, Murli, you can ask your question.
Hi, my question is specific to the H1 amendment. I applied the amendment and I got the RFE, and the RFE is relating to the knowledge and education with respect to the experience.
Okay.
So they specifically ask for how, because I did masters in electronics and communication at India.
Okay.
So now I have total 14 years of IT experience. I was here past 10 years. And my 140 is approved long back, maybe in 2012. So now my thing is now I applied for the change of the client. I need to apply for the amendment. I applied the
Correct.
amendment. So I got that query, that is the one thing. I would like to check with you, because I heard like a different kind of news and everything, how these things, how do you relate your education with your experience kind of thing?
Correct. So that would be like what we would call like a query into the specific specialty, right? So let's say, I don't know if you know you have a copy of your LCA, right?
Yeah.
And your SOC code is probably 151132. Software developer applications. Let's say you're a software developer, okay? So the Bureau of Labor Statistics and Occupational Handbooks say that SOC code typically requires a bachelor's degree in computer science, engineering, or something related. So what they're focusing on is that your degree is in electrical and electronics engineering, which is not the same thing as what they read in the book. Now, to overcome this, you can get an evaluation done to show your experience and everything else. And since you have 15 years of experience, that even if your degree is mechanical engineering or something completely unrelated, that amount of experience should be enough to meet the guidelines for a bachelor's degree. Okay.
Okay. So my thing is, what should I do to show? Because you see, now my employer asked me to write, because whatever responsibilities I sent to them, and he asking me to write the detail level of those responsibilities, and with the how much percentage kind of thing.
Correct.
Right? So
yes,
is that going to help or?
Yeah. So you probably also have some type. So that's also going to show specialty occupation if they want to show like the detailed job duties. It could also be, I've seen it requested before to show that where they say the description and the client letter, vendor letter is so generic that it's not detailed enough to meet the requirements of a specialty occupation. So we often require the beneficiaries to give us that information. And also for like an itinerary of services, it's very common, and it's very good practice to have that documentation done.
All right.
Okay.
Thank you so much, Murli.
Thank you.
Yeah. Sorry. Only one question.
Yeah. Sure.
One last one. You see, as you mentioning, right? How do you get the evaluation thing as you mentioned, right? Is there any form? Is there or any bureau or anywhere where should I get the evaluation done?
I would work with your employer and their attorney, and they would probably have some type of evaluation company that they use. And if that's the case, based on not being able to read your RFE in front of me, based on what you're kind of telling me, that's somewhat common practice.
Yeah, evaluation based on experience only, right? Not for education.
Both, actually, to my knowledge.
Oh, okay.
Yes. Yeah.
Yeah.
Okay.
All right. Thanks, Murali.
Okay. Thank you.
Thank you,
Murali. We have another caller.
Okay, bye.
May I know who's on the call, please? Hello? Hello? Can you hear us? May I know who's on the call? I still see someone is on the call. So, hello? All right. Lucas, yes. So, the question that I asked, I'm sure there is a risk involved whenever you leave the country and get it stamped, but amount of risk with layer just one and more than one?
That's a good question. What I would recommend is, obviously, you would want to have all your items, all your supporting documentation prepared before you leave.
Makes sense.
As previous, you have to have your W-2s, your payroll records. You need a letter from your employer. So you need to go through the procedure for all the evidence and not worry and focus on one. However, I'm familiar with what's going on, mostly Hyderabad and Chennai. So for most of what I've seen this past year at Hyderabad, everyone pretty much is receiving a 221G for admin processing.
Yep.
And the typical wait time is 6 weeks to 3 months.
Yes.
And it's not specific on layers. It's not determined by anything. I just believe that it's just just the process. They're pretty much checking everyone who's not eligible for just the Dropbox.
Yeah, you're right. And what's the Dropbox criteria?
So
I already had this question. So yeah.
So the Dropbox would be if you already have the stamp previously, if you're a certain age, if you're under 14, I believe, or if you're over 60 or something like that. Okay. You're and then also if there's no changes to your status or anything else from the previous stamping, then you would qualify for Dropbox. But most people that I encounter, they come here, like most of our callers today, they'll come in 2015 or 16 on F1. They change status, then they have H1B for a year or so, and then of course their parents say, hey, we want you to get married. They have to go back home, and then that's the initial stamping, and that's what's causing a lot of issues because, is your project going to be patient enough for you to be out of country for potentially 2 or 3 months?
Yeah, makes sense.
So, yeah.
So my question again. So I'll ask my specific scenario. I got stamped in 2016 November, and I had this. I had this approved 2015, and then my stamping was done in 2016 and expired on 2018, and then my extension was filed and it's approved till 2020 December 31st. So if I leave country and go back to India, will that fall into Dropbox criteria, especially for me? I'm thinking it is, but I want to know your thoughts.
It should. So,
and I have no change in employers, except here and there client changes.
So to qualify, you have to have a previous visa with the same class, which we already discussed. Mm-hmm. You're going back to where the visa was issued previously, right? Mm-hmm. Mm-hmm. You received your visa in the past couple of years, and you haven't had any issues of stolen visa or passport, or lost passport, and you haven't had any refusals that for your extensions or anything else, like a rejection
Yes.
Or refusal at a port of entry. And
None.
You just have to show that your H visa on a prior visa that's in the same class is still valid or expired within the last 12 months.
Makes sense. All right. And we have a caller on. Yeah, go ahead.
No, go ahead.
Express Rajesh Show ki swagatam. Hello. May I know who's on the call?
Hi, my name is Akhilesh.
Hey, Akhilesh.
Yeah. Actually, I had a question regarding the Day 1 CPT.
Go ahead.
What was so specific about the question? Could you be more precise, please?
Yeah. So my name is Akhilesh. So I'm currently enrolled as a Day 1 CPT student from University of Cumberland. So I'm currently working as well. So I just wanted to know, pertaining to the August 9th memo that was issued by USCIS regarding unlawful presence, will it have any impact for all the Day 1 CPT students, or is it any specific universities that have that doesn't follow the proper criteria?
Good question. So, like we discussed before, when you're here on any status, non-immigrant status, you have to maintain your status at all times, barring any exceptions that might exist. So for F1s, the main purpose would be to qualify. If you're going for second masters, you need to attend school a couple of semesters before you're eligible for CPT. Now, the institution itself can put together a program to say, well, to get the most out of our master's degree, we want real world experience or things like this. So they'll create a program where if you're in a similar field, computer science, you're doing computer programming or whatever, how is that furthering your education or benefit the education in the future? So it can, if you still, let's say you take CPT, and then let's say next year you get picked in the CAP, but you never attend a course at the institution. I mean, that could impact you, and especially from this August 9th date. They could go back in time and say, look, all the way back to here, you didn't maintain your status because you never pursued the studies. That's kind of getting into the gray area of where this might be going. So it's not illegal for you to pursue Day 1 CPT, but you need to be prepared to follow through if you need to go attend courses, follow the program curriculum, things like that.
Yeah, actually, University of Cumberland is an accredited university, and I have been we will have to attend the classes regularly. Like we will have the residency class for once in a semester. So we'll be and we need to maintain a grade of minimum 3 to be eligible for the next semester for the CPT. So yeah, I think we are following all the regulations as per the ICE and the DSU.
Yes, and also make sure that you just like for when you did your STEM extension, make sure you have your training materials, things like this. You want to have your course materials from Cumberland to show, what, and they'll give you 4 or 5 pages of what the curriculum works with, the courses, how they apply that to real world experience, things like that.
Yeah. Okay. Got it.
Thanks, Akhilesh. Yep.
Thank you.
Thank you.
So, Lucas, I have a question. So, how is it most likely, or what's the possibility, or let me phrase like this. So, can we change the client while the H-1B extension and the amendment is in process?
Good question. So, let's take example that you have H-1B approved, your project is going to end, and you found another project that's in a different MSA, right? Which is, let's say you're going from California to New York. If you're within 6 months of your ending validity period, you can go ahead and file an amendment with a request for an extension. Okay. So that way, that's best practice. Now, let's say, like right now, premium processing isn't available for amendment filings or change of employers, right?
Yes.
So let's say you file an amendment, and it's 9 months before you're required to file extension. So you have an amendment that's pending for 3 or 4 months, and let's say you still don't have premium processing available or you don't want to pursue that, you can then also file for extension based upon the amendment. Now, what's going to happen is the extension is going to issue RFE saying until a final decision is made on the amendment, you can't proceed with the extension. So, and it's two different service centers, right? So it would be, if you're not able to make it in that window of 6 months, you're going to be filing probably in California, and then the extensions all go through Nebraska Service Center.
Okay. How does this service center decide? Like, does this service center get like where to process? Does employer decide, or does the candidate itself decide based on his working? Oh, how does it?
So that's a good question. That this policy has changed quite a bit the past 3 years. So initially it would be, where the work would be taking place, or I guess initially it would be where the employer is located. Then they filed amendments based upon work location.
Okay.
So if you worked in New York, you'd file in Vermont. If you worked in California or
California Service Center.
California Service Center. And then they changed that to now where your employer's located. So if your employer, let's say, is in Texas, if for a period of time we would file in Vermont. This last year, they changed Texas to be required to file at California. So they're always trying to balance the workload. California has a humongous service center, and they process the bulk of all the H-1Bs.
Okay, and there's no hard and soul rule, like, it has only to be sent to so and so service center if the employer is
in the past people were creative to choose their service center. Some people would list 2 locations on the LCA. One of the locations would be in Vermont, in the jurisdiction for Vermont, so they could file with Vermont, because most people perceive California as a very, much stricter service center.
Is that a myth or is it real? Is it for real?
That's more of a myth. I think you have to put each case. You have to put each case together. You should never have any false security or anything like this. Makes to know, sense. Like, oh, I'm going to file. Every case should be prepared as if you're in the eyes of the attorney. Like, what's going to happen? How could this be denied? That's our job, to make sure we get everything put together as best we can.
Yes. And I have a caller. We can take a call. May I know who's on the call, please? Hello?
Hello.
Yeah. Who's this on the call, please?
Yeah, my name is Radha.
Hey, Radha.
I have a question. Yeah, I have a question. This is about an RFE and an extension which is due. So there was an amendment that was filed, and we got an RFE on that. And the extension is my expiry date is till the June of 2019. Mm-hmm. So the employer is saying that we're going to reply to the RFE. Right now I do not have a plan to change the client, but I have a SOW till August with this client, and for which we have applied the amendment for, and then we got an RFE. And the employer says that, my employer, not the client, but my employer is saying that he's going to reply to the RFE, and then we are going to apply the H1 extension too. So do you see any problem in this, or?
That's a very good question. And this is also going back to some current changes. There's a pending lawsuit, as we discussed, from ITServe, which is most of the employers that sponsor H-1Bs. The organization ITServe filed a lawsuit about the changes that were made. And so what you're concerned about is, okay, I want to file an extension, but the SOW is only for 1 month after or 2 months after my validity period expires. So
and then the catch was also, I'm looking for projects. It might get extended. That is the first thing, or maybe I find another employer even before that, because I want to find an employer. If this project gets extended for another 8 months or so, it might get extended, but I'll take care of that. But the application has to go in before that, right? So exactly. And then it's taking 3 months to 4 months time.
Very good. That's very smart on your part. I always recommend the same. If you can market yourself before the 6 months, if you feel like the end client's not going to commit to an extension, protect yourself and market and find a different project, and then you can approach them and or say, we have a different obligation. My employer wants me to join another project, and they can discuss it if they want to keep you or not.
So you would suggest to so the RFE is on the amendment with my current client. But if I change my client with, I get a project for an year or so for a new client. So you would suggest that the H1 the H1 application should go with a new client letter, or because I already have the amendment application with the current client, which I'm replying with an RFE.
Right. So that's just on its own, a separate case. So your validity period is going to be until this June, unless this amendment's approved, and they only approve it till May. You see, they can reduce the time. But what I would recommend, if the end client is not going to commit to extending beyond August, market yourself. And if you find a new project, and let's say you get a 2-year SOW, you can your employer right now can just withdraw the amendment and say, this case is pending. Our employees change.
Then apply, apply the H1 extension with the new client letter.
So it'll be a new amendment with a request for extension.
New amendment with a request for extension. Okay. Thank you so much.
You're most welcome. Thank you.
Thank you.
So Lucas, I have one more question, and then we can sign off. Let's say there is a person whose H1 transfer is in the process and who's working on the receipt, and its decision isn't made yet. And can he prefer to change the client once again? In that case, when he files a new transfer or new H1, the previous one would be withdrawn, or how does it work?
So to transfer employers under AC-21 and port over to a new employer, you have to have a valid, approved I-797, and your I-94 has to be valid. Okay. So if the I-94 is valid, you can transfer, and if the previous employer hasn't withdrawn, you don't have notice that they've withdrawn it, you can transfer to another employer. Now, your question is, let's say it's pending for 6 months, because premium processing
previous H1 is already revoked, and
then your current employer they're required to file an amendment if there's a change. So you would just file an amendment, because if you don't, you're going to risk losing your status from the Semio Solutions matter. So it's very important. And then always, there's so many complex things occurring right now. I always tell people, to finish up on this note, that everyone's case might be similar as far as the process goes, but everyone is unique, like your own fingerprint. No one is going to have exactly the same case. So if you read the message boards, or you speak to your friends, or if you're in a WhatsApp group, just remember, don't have so much panic, because you are, there's certain things of your case that no one else has.
All right. And that's a very well said about the fingerprint stuff, actually. Yeah, every case is similar, but the way it projects, we have to have a focus on each and every word that USCIS mentions and proceed based on the understanding, right?
Correct.
And
correct.
One last question, I promise. Can more than one H1 transfers be done in parallel?
Yes. There's you can have a secondary employer. Yes, the main requirement is going to be that your I-94 has not expired, and that you can port over.
Makes sense. All right. And one final word for all the United States current immigration fighters from your end.
I'm sorry. One
final message, or a final word, or final precaution message from as an attorney's point of view to all the listeners.
From my point of view, I just want to ask everyone to stay the course. Don't let people bully or change your perception. Everyone listening's worked very hard to get to the point where they are in their life. They've invested time and money and resources and sacrifice from being with family to make it to today. And don't let a bully or agency bully you to the point of giving up on that. And always have that hope with you. And if anyone needs anything, any assistance or speak, I can be reached at www.bgimmlaw.com.
All right. Thank you so much, and that was sweet. And it was pleasure having you in Telugu NRI Radio's show, especially in my show. And it's pleasure speaking with you, Lucas.
Thank you so much. It's been a pleasure. I look forward to meeting with you again.
And good luck with your movie assignment.
Thank you.
And don't forget to charge $1 million.
Of course.
Thank you,
of
and
course.
have a marvelous Monday.
You too. Bye.
Yeah. All right. విన్నారు కదా మంచిగా ఇమిగ్రేషన్ మీద లిటరలీ గట్టి వేసుకున్నాం ఒక గంట. అండ్ సీ యూ టుమారో ఇన్ ఆర్ ఎక్స్ప్రెస్ రాజా షో విత్ అ క్రేజీ సెగ్మెంట్. అండ్ మంచి ఎంటర్టైన్ చేసి 1 hour ఆక్యుపైడ్ ఉంచేస్తాను దానికి అనమాట. అండ్ ఇండియాలో ఉన్న వాళ్ళకి గుడ్ నైట్. ఆల్రెడీ పడుకున్న వాళ్ళకి హ్యావ్ అ ప్లెజెంట్ స్లీప్. యుఎస్ టైమ్ జోన్స్ అండ్ మార్నింగ్ టైమ్ జోన్స్ ఉన్న వాళ్ళందరికీ మాత్రం హ్యావ్ అ మార్వెలస్ మండే. సీ టుమారో. నేను మీ ఎక్స్ప్రెస్ రాజా శశాంక్. అండ్ వింటున్నాండి తెలుగు ఎన్ఆర్ఐ రేడియో. ఇది ప్రవాసాంధ్రుల గుండె చప్పుడు. నమస్కారం.